This is immigration attorney Asad Hafiz, practicing immigration law out of the Ninth Circuit. My office is located in downtown Sacramento, and I'm doing another immigration court cases law review for you, so to help improve a bit more understanding of immigration law as it evolves through the immigration court system. With no further ado, is a case from the Ninth Circuit. It's called U.S. v. Sineng Smith. It was decided December 4, 2018, towards the end of last year, and it undid a federal immigration law as unconstitutionally overbroad, criminalizing speech protected by the First Amendment. Law basically made it a felony to encourage or induce an alien to remain in the United States. Encouraging and inducing. What does that mean, to encourage and induce others? This lady's conviction was reversed regarding her immigration consultant services. Next one is U.S. versus Foster, Fifth Circuit, and it was decided December 12, 2018. It held that a defendant was entitled to a new trial on charges of transporting aliens. The prosecution's reliance on videotape deposition testimony of two material witnesses who had thereafter been deported violated his rights under the Confrontation Clause. Fifth Circuit case acknowledged from an evidentiary trial standpoint that your rights may be violated if you don't have a chance to confront the witnesses. If those witnesses have been deported later, the government can't rely on those witnesses. Next case is Idris versus Whitaker. This was from the Ninth Circuit, decided December 13, 2018. This is an immigration case. It held the decision not to certify an alien's ineffective assistance of counsel claim for review was committed to agency discretion. It wasn't subject to judicial review. The alien argued that his counsel failed to represent him properly in his removal proceedings. A common basis of relief can be if a previous attorney didn't handle the case effectively and is subject to an IAC, an ineffective assistance of counsel claim. So sometimes there can be relief when a previous attorney did not do their due diligence. But this case right here is an example of where it might not work. The person wasn't able to undo the outcome. Next case is Gahagan versus USCIS, Fifth Circuit, December 20th, 2018. Attorneys appearing pro se representing themselves cannot recover fees under the Freedom of Information Act, FOIA. The plaintiff, an immigration attorney, made certain FOIA requests in his own name and successfully sued the government when he was dissatisfied with the response. So an attorney in that sort of position is not going to collect attorney's fees under the FOIA statute. Next case is Cornejo Villagrana versus Whitaker, December 27, 2018. Included this one right here, Ninth Circuit case. It's a reminder that domestic violence charges, arrests, convictions can become a major problem for those who have a green card. Be very careful on one's best behavior if one is wrongfully accused even of a domestic violence scenario. It can pose problems. This next one is under the Fifth Circuit, Gotra versus Whitaker, January 4, 2019. It affirmed a Board of Immigration Appeals order denying an India citizen's application for asylum, withholding of removal, and relief against the Convention Against Torture, despite his claim that he feared persecution in India based on his Sikh faith and his political affiliation. And these cases don't always prevail. So they're very fact sensitive. So this was a case where the individual did not win. It went to appeal at the Board of Immigration of Appeals in the Fifth Circuit, and it was affirmed. So the individual did not prevail. Next one in the Ninth Circuit, U.S. versus Torres. January 8, 2019, it affirmed a conviction for possessing a firearm while being an alien unlawfully in the United States. They wanted to raise the defense of a Second Amendment. Well, this case basically pointed to you don't have Second Amendment rights as a defense against that statute. Next one is the Ninth Circuit, U.S. versus Valencia Mendoza, decided January 10, 2019. It vacated a sentence for unlawfully re-entering the United States after having been removed and remanded for re-sentencing. Charges of unlawful re-entry, which is a crime, a criminal action, can be reversed under the right circumstances. So this was one of those cases under the Ninth Circuit, U.S. versus Valencia Mendoza. U.S. versus Arellano Banuelos. This was decided January 14, 2019, under the Fifth Circuit. Remanded for further findings as to whether alien statements to a federal immigration agent should have been suppressed. Alien made the damaging admissions during an interview conducted while he was in a state prison. May be able to have statements suppressed under Miranda. That's another avenue for a motion to suppress evidence. And those are the cases I have, the recent cases I have for this series of the immigration case law updates. Visit my website. I have these cases, these updates regularly being updated on my page online. You can also go and check your I-94. I have a link for that which shows your current immigration status if you are immigrating, if you are on a non-immigrant visit to this country. You can also check what are the current processing times. I have a link for that. And if you're interested in exploring a possible case for you or a loved one, do not hesitate to give me a call, 916-836-5755. Feel free to visit my website, www.legalstrategiescompany.com, or send me an email at ahafiz@legalstrategiescompany.com. Thank you for your time, and I will see you next time.